year. And this particular training is going to talk about involuntary commitments in juvenile court. It is my pleasure to introduce Ben Turnage, who is special counsel at Cherry Hospital in Goldsboro, North Carolina. He has practiced law in Wayne, Greene, and Lenoir counties, working primarily in the areas of indigent defense. He's represented defendants in district and superior courts, in addition to representing parents in abuse, neglect, and dependency cases, juveniles in delinquency court, and respondents in guardianship proceedings. His duties as special counsel also includes serving as a resource for appointed counsel representing respondents in civil commitments cases. I'm so excited to have him here today to talk about this important issue and the intersections of our two courts. Throughout the presentation, if you have any questions, please just enter them into the chat. If Ben gets to a slide that you have a particular question about, please feel free to unmute yourself and also to ask question at that point too. We want it to be as interactive as possible. But at this point, I will turn it over to him and we will get started.
Yeah, thanks, Yolanda. I appreciate you inviting me to speak to the group. So I'll just go ahead and jump in. So 98% of kids committed to YDC have at least 4 mental health diagnoses, according to the Department of Public Safety. Imagine that. And in North Carolina, a juvenile may be actively involved with the Division of Juvenile Justice and a county Department of Social Services, as well as the mental health system. And this is the reality when you're representing juveniles in a delinquency proceeding. Now, I have been given a little bit of insight into your questions, and I'm hoping that I've been able to touch on many of those, and I'd like to hear from you about it. But these are the questions that I understand may need to be addressed in some way. Your client is in detention, and everyone agrees that treatment is more appropriate, yet your client remains in detention. And we'll talk about Department or Division of Juvenile Justice Resources, the Ombudsman, Division of Child and Family Wellbeing, and Medicaid ambassadors. Then you've been appointed and your client is in treatment, but you don't know where. So we'll try to answer the question, where are they? And who knows what's going on? We'll talk about how pre-adjudication assessments can create some of that mystery. Then you may have a question about, where your client is being treated and you want contact, plus you want to continue to advocate on their behalf, maybe. And we'll talk about continuing to represent the juvenile during facility treatment. Or the disposition is treatment and the facility discharges your client. And so we'll talk about a care review team. I'll mention, I'll kind of advocate for a care review team in as many cases as possible. We'll talk about children in DSS custody and the continuum of care, and necessary treatment being the objective. Another area of concern was that your client has mild developmental delays and they have a diagnosis of emotional disturbance, otherwise known as a dual diagnosis. And we'll talk about children with complex needs. Or your client can assist you in their defense at an age-appropriate level of understanding. So we'll talk about a little about the ITP process just briefly. And then finally, the question has arisen, your client's been in treatment for several months prior to disposition. Is there credit toward the disposition? And we'll talk about some guidance on credit for treatment. So let me hear from you if I'm covering those areas you want answered. Let me know. Give me a thumbs up, or if there's anything in addition you would like answered, just type it into the chat. So here's the intersection of 122C commitments and 7B delinquency court. These are actually separate proceedings. Commitments are involuntary commitments, and voluntary admissions of juveniles are accomplished pursuant to 122C. The jurisdiction is going to vest in a commitment court, and venue is in the county where the facility is located. The special proceedings clerk in each county is going to maintain a file for their respective cases. So if you have a client in Johnston County and that client is going to go to a PRTF in Lenoir County, then the Johnston County clerk, of course, is going to have the juvenile delinquent file, and Lenore County is going to have the special proceedings voluntary admission file. Now, there are the considerations during disposition in each type of case are that both residential and non-residential treatment are contemplated, and that the MCO level of care continuum is going to be identical regardless of the referral source. And your clients and mine are subject to that continuum of care if they're going to get some sort of treatment outside of Department of Juvenile Justice or some other care placement. If you're talking about 122C, you're talking about managed care, and you're talking about Medicaid. So there's also a potential for more restrictive placement in 122C commitment. Discharge from a PRTF and from other 24-hour facilities depends on achievement of treatment and behavioral goals. And that can go on for some time depending on your client's behaviors while they're in treatment and whether they engage in their own treatment. And in PRTFs in some 24-hour facilities that are not state operated are really, they're much maligned for kind of poor conditions and for poor treatment of consumers. So be aware of that as well when you're asking for some treatment outside of juvenile court. And maybe look into the place where your child might be going. And then there's also a focus on rehabilitation in both areas, 122C and 7B. In every case in juvenile court, the court may order a mental health examination. If there's evidence of mental illness, substance use disorder, or severe emotional disturbance, the court is going to refer the juvenile to the managed care organization, possibly for an interdisciplinary evaluation. And the commitments in a 122C case is going to be in a hospital as well as a juvenile delinquent case if they are committed to state hospital or are in a PRTF that's part of a hospital facility. And those treatment centers and facilities are going to treat mental illness and substance use disorder, and they're going to restrict liberty to the extent that a judicial review is required under 122C. So this is what the intersection ends up looking like in so many cases, because there are so many referral sources, beneficiaries, agencies, and programs, and money managers that the intersection can become very crowded. So hopefully I've organized the information I'm going to present in such a way that maybe it'll just clear up some of that congestion. So this is the way I envision the interface between 122C and 7B. If the juvenile's mental health is a concern, of course, then the parent or DSS or the Department of Juvenile Justice is going to know first that the child is going to need some mental health treatment. The juvenile court counselor and DSS are going to share information. They can do that pursuant to statute quite freely. And the court counselor has access to all the resources of the Department of Juvenile Justice as well. The Department of Juvenile Justice has some direct access to the managed care organization. And the managed care organization is going to evaluate the needs through a provider system and approve financing for any sort of treatment that's recommended. Now, the juvenile defender is going to have direct access, of course, to the court counselor. And what I hope to do is show that the juvenile defender may also exert some influence with the MCO, and that also there may be some communication between the juvenile defender and commitment counsel if necessary, depending on the placement. Commitment counsel is going to be the last one to the party, and what they're doing is in providing client-centered representation, we're going to defend a juvenile that is facing commitment after everyone else has worked so hard to create a treatment plan and has achieved the goal of providing treatment. So you can see that at times it's possible that the goals of the client might be different in the commitment case than they were in the juvenile delinquent case, And I'm going to suggest that maybe the defender and the commitment counsel can work toward the end of having the juvenile engage in their treatment if that's what is recommended and necessary. Although, of course, commitment counsel is going to continue to provide client-centered representation. So there are 4 types of judicial hospitalizations. You can see those here in this slide. The burden of proof is on the petitioner in an involuntary case. The burden of proof is on the applicant in a voluntary admission. And so what arguments can be made to avoid commitment, involuntary commitment? Well, commitment counsel is going to focus on whether treatment is being provided at the least restrictive level of care, and we want our client to be in the community. Other defenses focus on, of course, expert opinion, whether there are sufficient resources in terms of family and friends or others who can help our client return to the community, and whether the crisis has been averted and the respondent is stable and ready for discharge. There's also involuntary substance abuse treatment or voluntary admission, which we'll speak to in just a moment, or incapable to proceed hospitalization, in which the respondent is mentally ill and dangerous to self or others, but they're unable to assist the defender at an age-appropriate level. And so that's essentially an involuntary commitment where there's the extra piece of having a forensic service provide restoration services. Let's first talk about the outpatient commitment. Commitment counsel would like to see our client again, return to the community, maybe on an involuntary outpatient commitment. Now, an outpatient commitment is involuntary, and it's although the respondent is not considered dangerous. And by the way, voluntary commitments don't require a showing of dangerousness either. If the respondent doesn't comply with the outpatient commitment, then the provider may contact the clerk of court and have the clerk issue a pickup order so that the respondent can be brought in for an evaluation to see if the respondent requires involuntary inpatient treatment. And so what are the criteria for outpatient commitment? It's that the respondent is mentally ill as defined for minors, which means they have impaired capacity to exercise age-adequate self-control and judgment in the conduct of activities and social relationships that the minor is in need of treatment. They're capable of surviving safely in the community with available supervision from family, friends, and others. Based on the psychiatric history, though, respondent is in need of treatment to prevent further disability or deterioration that would predictably result in dangerousness. And respondent's current mental status negates the respondent's ability to make an informed decision to seek treatment voluntarily or to comply with recommended treatment. So we'll make a pretty short work of the incapable to proceed process. It's an hour-long CLE in itself. I'll refer you to a School of Government civil side blog post by Jackie Green from February 25th of this year for details on the ITP commitment process for juveniles. There are new forms, and once the juvenile is found to be incapable to proceed, the juvenile is subject to orders of the delinquent court for remediation services. If the court decides that the juvenile is not likely to attain capacity in the foreseeable future, the court may initiate an involuntary commitment custody, and they'll issue essentially an involuntary commitment custody order. However unlikely it may be, there may be a waiting list at the 24-hour facility. And in that event, I suppose the division has to determine whether the juvenile is going to be detained pending acceptance by the 24-hour facility, the state hospital. When the juvenile is admitted as an involuntary patient pursuant to 2401.5, a judicial review is going to be required under 122C, and the juvenile is going to be entitled to a periodic judicial review of their continuing commitment until the forensic process is complete. The courts must find commitment criteria for the juvenile to remain in the hospital. However, 122C requires that the incapable to proceed respondent shall not be discharged without a forensic report being filed with the court. So that is a factor in mitigation so that you can be fairly well assured that your client's not going to pop right out of the hospital if they are in need of a forensic service. So in the authority for involuntary commitment is 122C 261, and this section applies equally to juveniles and adults. When a petitioner thinks that another person is dangerous to themselves or to others, due at least in part to mental illness, they can seek a custody order for involuntary commitment. The petition initiates a judicial process for restraint of respondent's liberty and transportation for commitment examinations at approved facilities. There's a 24-hour limit on service of the custody order, and there's a 24-hour limit for each examination that's required. The clock starts to run on delivery of the respondent to the custody of an examination site. And it's important to remember, though, that at any point within this flow chart, that any examiner may release your client from custody pursuant to statute, or release your client to outpatient treatment, again, pursuant to statute, without regard to the juvenile court's plan for treatment. So I'm going to show you Mark Bott's flow chart here. It's available at the NCDHHS website. And you can see that Mark Bott's indicates there are three types of petitions. The layperson petition is what you're going to be dealing with most likely in the juvenile delinquency case. And that can be brought by a parent or anyone that's involved. Maybe even maybe someone at the detention center could bring a petition if it appeared the child was in need of involuntary commitment. The difficulty arises, though, in the emergency department. That emergency department is the first examination site in the community where the juvenile will be taken to see if they meet criteria for continuing involuntary commitment and restraint of their liberty while a bed opens up at the 24-hour facility. And many times children are going to be discharged from an emergency department. As you can see here, that's available to the doctor that's seeing them in the emergency department. If they don't feel that the child meets commitment criteria, they can just discharge them out of the emergency department, and their parent or guardian will have to come and pick them up, or perhaps someone from the Division of Juvenile Justice. A lot of times the doctor will just say that the child presents behavioral issues. That's it, and this must be attended in the community. So obviously involuntary commitment isn't necessarily going to be your pocket solution. We'll see in a moment that that the Department of Social Services has some statutory authority on a discharge from the emergency department under 122C 142.2. In my mind, it signals that perhaps, and this may be way off base because I don't practice in your area, but that a care review team would be helpful in any case where it seems that the juvenile has severe emotional disturbance or severe and persistent mental illness, so that this event doesn't happen. The care review team could perhaps make a better recommendation than an involuntary commitment if it seems that the general practice is that in your area, especially, that the emergency departments won't hold on to children while they're waiting for a bed to open at the 24-hour facility. And again, in my experience, most of the clients I see are that are qualified for a 24-hour facility, they are actually in DSS custody when they get to the facilities where I work, which are Cherry Hospital, and also I represent respondents at Nova PRTF in Kinston. And that's not the case in every delinquency case, I'm sure, but that is what I see quite a bit. And if that's not your experience, then the remedy for an unexpected discharge will be somewhat limited, and you'll have to exert some influence, perhaps through the Medicaid ombudsman, or perhaps the Division of Juvenile Justice can help in some way, or maybe you have an advocacy liaison at the Office of the Juvenile Defender. But we'll get into this a little bit more in a future slide. So here's the legal process for a voluntary admission, and thereafter for a continued stay for. A voluntary admission is begun by application for admission filed by the legally responsible person. And the application is the initiating document that confers subject matter jurisdiction to the commitment court and takes it out of the delinquency court jurisdiction. The application must be in the court file, in the special proceedings court file, that is, along with the facilities evaluation of the minor respondent. This statutory scheme balances the liberty interests of the minor against the rights of the legally responsible person to address treatment needs of that minor respondent. And then judicial concurrence with the necessity of continued treatment and the particular level of care is required at the initial hearing, which is due in 15 days after the case is filed with the clerk. And that, that goes from the initial review hearing to then a rehearings that are required at intervals of 90 days and then 180 days. From the standpoint of commitment counsel that it's representing a young person in a PRTF, there must be some available alternative to placement in a PRTF before a judge will even entertain the thought of discharging the juvenile from the PRTF. That's my experience in this district. So I don't see any questions, so I can't see them. So I'll just proceed until Yolanda, if you'll just let me know if there's anything I need to speak to.
Nothing just yet.
Okay. So at this point, I'd like to just mention again that it's possible that a care review would allow you to advocate for a community commitment, which would include a PRTF, that although it will require judicial review under 122C, if you have a care review of the case and you bring together all the people that are involved in the care review, they can make some decisions about funding and make some decisions about availability of the location of treatment and the level of care. And perhaps you can avoid some of these very fast discharges from facilities, including emergency departments and involuntary commitments at state hospitals that you didn't anticipate whenever you were trying to work something out for your client on a disposition. And I understand that Department of Juvenile Justice also has perhaps multi-purpose group homes, which would then also be less restrictive, and they don't require judicial review under 122C. So what is a PRTF placement? Well, that is a non-acute patient setting. It's for treatment of children who are mentally ill or substance abusers, and they have to receive treatment out of their home setting or some other community-based residential setting in order for them to receive appropriate treatment. A non-acute, what does that mean? It just means that your client is not in crisis, requiring a higher level of care. And we'll talk about the levels of care here in just a moment. And now, if you're looking for the best alternative, I would say, to YDC or a lengthy detention, you might find that a PRTF admission is best. And you'll be more satisfied, perhaps, with the control that's offered by the structure of the PRTF setting and the treatment team model at the PRTF. I'll mention that again as we go forward. But for now, this is some general information about what the PRTF placement is, in fact. North Carolina does require a judicial review of a PRTF placement when a child is admitted to the 24-hour facility that has the same or similar restrictions on the child's freedom of movement as a state-operated psychiatric hospital. Mostly these young people have a history of leaving their home without telling anyone where they're going, and they actually require law enforcement assistance to return to their home or community setting. And we used to call it running away from home. And a PRTF level of care is highly structured. It's a locked and secure residential facility. Typically, the behavior management plan is for a minimum of 6 months. And of course, as you know, YDC is a period of at least 6 months. So there's some little bit of consistency there with what your court may be looking for. In general, the minimum stay in a PRTF program, as I said, is up to 6 months, and that's based on Medicaid requirements. The PRTF must begin planning a discharge as early as admission, so they have to have very frequent reviews for potential discharge, and that's to satisfy Medicaid so that they can secure payment for the placement. And discharge is going to depend solely on achievement of treatment and behavioral goals. So the process for admission to a PRTF, aside from the legally responsible person making application, is that the MCO is going to require a care needs assessment and a level of care utilization review for approval of funding. The legally responsible person, as I said, makes the application on the assessment, and the process is monitored by the Division of Medical Assistance. Provider Network will complete a score sheet for the managed care organization based on criteria indicating that the restrictions of a PRTF are appropriate. And this score sheet is known as a locus, or a level of care utilization scoring system. And it's required in the admissions packet at the facility. So why have a judicial review under 122C? Well, the purpose is to protect the child's liberty interests, since they're not free to come and go as if they were at home. They can't say, I'm going to run down to the store and get me a soda and a bag of chips. I'll be right back. They have to have a certain privilege level, or they have to go off campus, or they have to have a medical appointment to go off campus. And the judicial review then is to make sure that the child has not been improperly admitted, or whether the child improperly remains at the facility. Are there any questions about the PRTF slides that I've gone over so far? All right. So if someone enrolled your client in treatment outside of delinquency court, and you're trying to determine how did this happen, then you can just ask, where did this begin? And it may have begun in DSS court. They can order an evaluation as well as care coordination with the MCO under 7B 903. And third parties can petition a magistrate for involuntary commitment of a juvenile. And also a legally responsible person may coordinate with the MCO for PRTF placement on some sort of clinical recommendation from the community. And that can happen without you knowing about it. It can happen prior to your appointment or after your appointment, but before you reach the adjudication hearing. And if it's necessary to find out even more, then you can, you need to determine maybe who knows what's happening. And here are the players and how you can get information from each of them if you're at a loss for some reason to determine why your child is in treatment. Again, the court counselor is probably going to be the best information for you, and probably the fastest information for you. They should actually be notifying you if your child has been placed in treatment. But if they don't know that information for some reason, or there's some communication breakdown for some reason, you can obtain releases from your client's parent to get information from the clerk of court, perhaps, or the 122 facility if you know the facility. Now, if you find out that the case has happened in DSS court and you're trying to determine what exactly was the reason for your child being put into treatment, you can make a request under the statute. And the guardian ad litem, the attorney advocate, would also be authorized, I believe, to disclose information to you about the juvenile. And since you're the attorney who's representing the juvenile in the delinquency action, does anybody have any experience in this? If you give us a thumbs up or indicate in some way, or maybe want to speak to that, I'd be glad to hear it.
I think Kaya Lynn raised her hand. Oh, maybe not.
Yes, hi. I work with minors. I'm a mental health attorney. I usually only really deal with like the staff at the hospital or like the child's therapist. I try not to contact the parents just because I do service facilities. So I do believe that it's the facility's job to contact the parents. And sometimes with DSS, it's honestly hard to get in touch with them, either due to their caseload or something like that, or they don't really understand my role. So they're kind of hesitant in giving me certain information.
Okay.
And the GAOs too sometimes are a little iffy because, again, they just don't really understand who I am. So I mostly kind of contact or talk to the staff at the facilities.
Yeah, that's a great idea. That's a great option for you. So do you do commitment cases?
Yes, so I do IVC cases at 5 facilities in Mecklenburg County.
Okay. Do you also do delinquency court?
No, I don't do delinquency court.
Oh,
I'm on a like a defense team, so half of my team does defense, and then I'm the one that does the mental health.
Okay.
Mhm.
Let me ask one other question then. Do you do any DSS cases representing parents in abuse neglect court?
No, I don't represent the parents. I do make DSS reports, depending on what my minor tells me, or just reading their file if it's something I feel like DSS should be involved in. Sometimes I do talk to the staff regarding like a DSS case, like if the minor is about to be discharged back to the parent, or they have a case coming up separate from mental health court. I kind of try to get more information on that just to service my child.
Sure.
My scope is kind of limited, so I'm unable to help them once they leave the facility. I kind of can only really assist them while they're at the facility. So that's a bit of a challenge for me.
Yeah, well, I mean, all those are excellent recommendations and perfectly appropriate and very intelligent things to do whenever you're trying to pursue information, investigate a case, find out what's happening. You pretty much have to do the best you can with the players that you have to work with. I'm not sure because of the breadth of the group that we have here today and what their practices might entail. I'm not sure what they need in terms of information about who to contact. So I'm trying to cover all the bases of what someone might do that would be helpful when investigating your child being in or the juvenile being in treatment.
Okay.
So yeah, thank you very much for those for that insight. It's very helpful. I think.
Thank you.
Thank you.
Then I think Anthony Masters also had his hand raised.
Okay.
Yes. So I actually work with Kaya. I helped to train her. We both work for the Council for Children's Rights.
Okay.
And
Yeah.
I did her job for 3 years. I have actually moved over to delinquency, so I have a little more insight into the before. A lot of the cases that Kaya gets doesn't actually have like any delinquency ties, but there are plenty of cases that come and start in the delinquency court, and then once we get really looking into it, DJJ gets involved. We start really digging into what does this child need. A lot of times we find that their behaviors of alleged crimes really are just behavioral problems that need to be addressed in a PRTF setting or some kind of like crisis. We've sent them to crisis units. We've sent them to PRTFs. And a lot of times it's really just, this child needs a CCA. a comprehensive clinical assessment of what do they need.
Right.
And we address their behaviors by sending them over Kaya's way. And then sometimes we have crossovers where she'll represent and be like, yes, this is what they need. It's not always just trying to get the kid out of the facility, or it's finding what they need until they don't need that level anymore. And we can get them down to hopefully a group home, a foster care, that gets treatment, outpatient, and that's the ultimate goal.
Yeah.
Because delinquency court isn't about trying to sentence the child for what they did. It's about what does this child need to become a productive member of society once they reach the age of majority. So we're trying to get them on the front end. And I'm sorry, I'm not trying to hijack your CC.
No, not at all.
No. But that's just kind of Kaya and I are in a unique position because we've done this work for so long that we give a little insight into weird boots on the ground. This is what we're seeing is I get a kid who allegedly committed a crime. We're not trying to just throw the book at them. What do they need? We send them Kaya's way. She represents them while they're there until they no longer need it.
Yeah, so that's kind of the direction I was headed in. Exactly what you're speaking to here is that, that's why anytime you can do a CCA, as you mentioned, comprehensive clinical assessment, or have any sort of care review team, any sort of team approach to representing children, regardless of whether it's delinquency court, DSS court, or whether it's in commitment court, that team approach is going to put together resources that are available in the community, and it's going to, have the best outcome. Of course, I'm not trying to advocate for a best interest type representation, because that's not what we're doing. We're trying to provide also client-centered representation. But like you said, exactly. I mean, everything about kids is unique. You have to approach them from a unique standpoint, and whatever the outcome is, you want to make sure that there are treatment locations available, that everybody's aware that the child's coming their way and they're ready to take those kids and do what needs to be done to help them to, as you say, to get better if that's what's required. So thank you very much. I appreciate that. So then let me just mention pre-adjudication assessments. Does someone have their hand up? Maybe that was
I think that was if it was from Anthony. I think it was just they kind of stay for a bit, but it's down.
Oh, okay. As previously. Okay. So let's talk just a second about pre-adjudication assessments and how they can kind of I guess sometimes confuse the system a little bit. For example, a school therapist might recommend an assessment to parents, and the parents will then follow up as recommended by the school counselor, and they might obtain that assessment through a provider that the school counselor recommends. And from that assessment, then they contact through that provider, they can contact the managed care organization and actually set up some sort of treatment. And that all can be done outside of a court system, and it's done from the community. And nobody in the court system knows what's going on. So I guess the idea is that I'm approaching this from the standpoint of a person that's a defender that's going into court with a juvenile accused of a delinquency case, and they're going into an adjudication, but they are having trouble contacting their client, or they don't know where their client is, and they find out maybe at the last minute that the child is in treatment somewhere. So this is giving some idea of how this happens, why it happens, and kind of where to start in order to determine what your next move might be, or what you need to explain to the court, so that you can maybe continue the adjudication or reach the best outcome for the juvenile, regardless of the delinquency case that's pending. Now, I know there are varying degrees of seriousness of allegations, and every case can't be handled as as lightly as I've just recommended, but certainly I think it's in general maybe a pretty good idea to try and approach it from that standpoint. And of course, the parents can the parents can actually petition for involuntary commitment without the defender's knowledge. Now, in North Carolina, children referred to PRTFs have to meet criteria outlined in the Division of Health Benefits Certificate of Need. I'm just putting this in a slide so that you'll see what that looks like in representing respondents in PRTF setting. I always look for these certificates in the chart so that I'll know that everything's been done appropriately in terms of their referral to a PRTF setting. And I'll also look for the level of care utilization system report and any other certificate of need from the managed care organization. So PRTF has to be accredited by the Joint Commission in order to receive Medicaid payments. However, they are not a state facility, and I really just mentioned this to segue to the next slide about guidance on credit for confinement. Again, delinquency court is not my area, but I was given some insight into what the questions might be. And so credit for confinement for mental health treatment is maybe a concern. And I really can't find any guidance for crediting time spent on commitment for mental health treatment, whether it be voluntary or involuntary. I would just say that arguably any grant of credit for an adult receiving treatment while in state custody should apply equally for a juvenile receiving treatment while in custody and facing a dispositional order. The court counselor may be suggestible as to what credit, if any, they support is applicable. As I said, a PRTF is not a state facility. So, you know, you may have a district attorney that would say that credit is not available based on this State v. Stevenson case. I don't know if that ever happens, but it's something that I see in publications that are talking about jail credit for adults. But it really just appears to me that treatment should simply be the disposition. I mean, credit would in that case kind of be redundant. And I'll explain that a little bit further in this next slide. So a PRTF works on a treatment team model, and achievement of treatment and behavioral goals is the benchmark without regard to delinquency court dispositions. And this is true for the 122C PRTF facility because Medicaid requires that accomplishment of treatment behavioral goals be a benchmark for discharge. Medicaid requires that as a condition of funding for the placement. So once goals are achieved, the team is going to focus on a return to the community. And I think David Andrews makes the point a bit better in the defender manual that your argument should be that services prior to disposition maybe have met the purposes of disposition if the juvenile has received a great deal of treatment prior to the disposition in the delinquency case. Does anybody have any questions about or concerns about what I've just said in regards to credit for time served, I guess is one way of saying it. If not, then as I mentioned, the North Carolina Division of Medical Assistance sets criteria for Medicaid coverage on a PRTF admission. There's got to be mental illness, a substance use disorder, emotional instability, such that the 24-hour care is required. There must have been attempts at community treatment prior to referral to the PRTF. That may be a barrier at times for a juvenile coming straight out of delinquency court if their lower levels of care have not been attempted. I don't know what your experience has been there. If you want to let me know that, I'd appreciate it. It might be helpful to me in my practice. There should be multiple previous hospitalizations without successful outcome and failure of appropriate support in a home environment. And ironically, Medicaid law is more restrictive than 122C as to criteria to restrain a child's liberty for purposes of treatment in a PRTF. And, you know, by the way, this is, you know, I see a lot of kids in DSS custody that are in a PRTF or an involuntary commitment. That's not true in every case. But I would say that if you look at criteria 3.2.1F, you know, it talks specifically to the family situation being such that, you know, the child can't remain in the home and receive treatment. Now, that doesn't mean that the parents are neglectful, but I do believe that some children are placed in a more structured setting because their parents can't maintain them in the home safely, and that maybe there are a lack of services in the area that the child originally resides, where the child originally comes from, where they were originally living. So once a child is admitted to a PRTF, your client shall not be discharged from the PRTF other than, you know, by court process, of course, under 122C. But just otherwise, there's no discharge without the advance written notification of the treatment team and of the legally responsible person. And I would say that perhaps there might be a request by the guardian or custodian. And if the guardian or custodian is requesting discharge from PRTF, they have to do that in writing. And then the team meets to determine whether discharge is appropriate. But if that happens, court counselors should be among the first to know if your client's going to be discharged, since they're part of that treatment team at the facility, and if they're choosing to participate in the treatment team process. There is no specific rule in the administrative code that directs treatment team action on a judicial discharge. My experience as commitment counsel is that the court is going to require completion of the behavior program, and that is the commitment court is going to require completion of the behavior program and a viable option for placement prior to the court even, you know, entertaining the thought about discharging the respondent out of the treatment team, away from a treatment team at a PRTF. Now, I'm sure that I have heard of attorneys in other areas that, in other districts, that are successful in getting a court to discharge their clients from PRTF treatment, but I would it would be a kind of a Sisyphus type situation. It's an uphill for me to do that. I don't have access to funding. I have no expertise to provide a needs assessment or a locus score favoring a lower level of care, and no legal authority to plan a community option. And of course, I'm not crying in my coffee, but I'm just passing that along as my personal experience.
Ben, there is one comment in the chat that says the trouble that we have in northeastern North Carolina is that there aren't any providers, so less restrictive treatment isn't available locally. And while services may be covered by insurance, the travel expenses and time off work are not reimbursed, and that can absolutely make or break some families.
Sure. Yes. So I'm hearing that there are no less restrictive alternatives, that if they find one, then the travel is going to be cost prohibitive. I would say that I'll give you some information about how to contact the Medicaid ombudsman in a future slide is coming up. I don't know if you've tried that before. There are also Medicaid ambassadors that possibly you could contact to see about the availability of funding. I think maybe 1915I is a provision in Medicaid. If a child is going to return to a community-based setting, perhaps there might be some provision for transportation. Also, money follows the person. We'll talk about those things in just a second. I'm not. I apologize for deferring, but if you'll give me a chance to get to that slide, maybe I'll be able to answer that question a little better. Now, you may be able to have some influence in the commitment case if your client is in a PRTF, even though the case is in another court, and maybe even in another county. If you just tell your client, hey, have the attorney that you meet when you get to the PRTF give me a call. Make sure your client has your contact information. I'd be more than happy to contact the defender on the delinquency case and discuss with them what the needs are for the juvenile while they're in the PRTF setting in order to satisfy the delinquency court. You know, again, I'm going to be providing client-centered representation, but I would say that communication is probably the best practice, and defender intervention prior to their client arriving at a PRTF may avoid this confusion on behalf of their client as to whether they're supposed to ask for a discharge when they're talking to their commitment attorney. And the reason I bring this up is because at the PRTF where I work, we have kids that come from all over the state. I mean, I'm representing probably 6 kids right now that are from Buncombe County and the western part of the state. Some of them have come from PRTFs that are in South Carolina. I mean, so just be aware that there's a lot of traveling because of the lack of resources, as you just mentioned, as the questioner just mentioned. So you're already familiar with the care review team, and that's, of course, the assessment that's reported to the delinquency court for potential disposition. The treatment team at the facility is a different matter altogether. And if you're a defender on a delinquency case and you're trying to get access to the treatment team process at a facility, this is going to require you to have access to information that comes from all the various disciplines that are participating in the treatment team process at the facility. And neither you nor I are typically involved in these meetings. I have in the past asked to participate, and I've been allowed to, but I've also been required to have a protective order entered in some cases so that I can get all the information that might be revealed in a treatment team meeting. And that, you know, in particular, educational records, interagency information, DSS information. I don't know if any of you have attempted to participate in treatment team meetings at the facility, but you can see that it may require you to do quite a bit of legal filing to gain access and you might have to get a court order for it. Now, the court counselor is going to be a part of this treatment team. The facility is going to notify the court counselor of the date and time. They're going to allow the virtual participation by the court counselor. If you're confident that the court counselor is going to attend and report to you, then there's no problem. If you want to try the easy method first, and like I said in the past, I've had some success with it, you might want to just tell your client that to have their community affairs coordinator or the therapist at the facility to include you as part of the treatment team meeting. If there's some particular reason why you might want to participate in maybe the initial meeting, for example. So what about the delinquency court? What can the delinquency court do to try to keep up with what's happening in the 122C arena so that the child is not discharged without the delinquency court having some prior notice of it, or at least the players in delinquency court having some prior notice of it? Of course, as I mentioned, the Division of Juvenile Justice can participate in the treatment team and report to delinquency court shortly afterwards as to what happened, if there's going to be a review as to the outcome in a treatment team meeting, at least that initial one. I don't know if that ever happens in delinquency court. The attorney advocate for the guardian ad litem could seek release of information from the court file in the voluntary admission case so that, for example, the court order, so that court order can be provided to the clerk in the delinquency proceeding. Now, the legally responsible person can notify the clerk in the delinquent case of the date for the initial review of the voluntary admission case at the 122C PRTF so that the clerk may schedule a review hearing in the delinquent proceeding shortly after. And the delinquency court may want to order that the PRTF make timely efforts to secure a post-discharge placement, so that perhaps transportation is not an issue, and so that maybe some placement can be identified, and maybe funding can be arranged for the child to be not so far removed from their parent. Again, this is just kind of brainstorming, and I would like your input on it if you have any. And then the legally responsible person can notify the clerk of a need for a review hearing if the legally responsible person files a written request with the PRTF for the child's discharge. In other words, if the parent doesn't want the kid to stay in the PRTF for some reason, the delinquency court can order the parent to report to the delinquency court if they're going to submit a written request for discharge from the PRTF even against treatment recommendation. So here's the procedural information for evaluation and treatment under 7B2502 found in the Defender Manual. And again, commitment to a PRTF has to be under 122C. So you all have seen this flow chart before, I'm sure. I just wanted to make sure that you know that when 122C becomes important in a delinquency cases in this area, where the care review team recommends a out-of-home placement that is where liberty is restricted and judicial review is necessary. So evaluation and treatment is an option in every case. According to 7B2502, an expert examination is ordered. Has anyone that practices in delinquency court used one of these orders prior to disposition? If you could give some indication, maybe Yolanda could let me know.
Nothing in the chat just yet.
Okay. So we get to disposition, and the judge is going to review the needs assessment and then enter the disposition after reviewing that, and maybe a recommendation of a care review team, certainly on a level 3, where there's indication that the child has serious emotional disturbance, and out-of-home placement is recommended. Now, my experience with this delinquency statute is that I've asked a PRTF to notify me if a child is subject to a court order for treatment at the PRTF, and they tell me they're not going to give me that information without a protective order. And so I tend to just ask my client. And sometimes my client either doesn't like the outcome of delinquency court, which of course could be recommended participation in any of these treatment programs, which requires 122C review. But especially in the PRTF, they may not like being in the PRTF. They may not like that they have gone to delinquency court, and so they may not tell me about it. And I can't get the information that easily within this short period of time required before the judicial review of the 122C commitment. So I'm kind of at a loss. And as I mentioned, communication can be the key between delinquency, a delinquency defender that knows their client is going to a PRTF, and the attorney that's representing the respondent in the commitment case. All right. So I wanted to point out also, it looks like that this area is again the area where 122C judicial review is going to come into play. And then this multi-purpose group home, as you may already be aware, that's operated under the Division of Juvenile Justice, and that doesn't require a 122C review. I'm sure you all are aware of that, but it just came to my attention as I was looking at these orders. And then finally, this is the order where there's been the needs assessment and the care review team recommends PRTF or treatment in lieu of YDC. Now, the care review team is to develop a recommendation plan for appropriate services and resources that address identified needs of the juvenile and submit that recommendation to the court at a hearing that's established ahead of time. And it looks to me like in the statute that this is contemplated more in the case of a level 3 disposition. And, you know, certainly then it's perfect time for that to happen. But I'd also say that if it's at all possible, if the child has severe emotional disturbance or a severe and persistent mental illness, that, you know, you might suggest a care review team, even on a level 1 or level 2 disposition. Now, somebody on the call may know that that is not a statutory outcome, and you can let us, and you can call me out on that, and I'd appreciate knowing that. But I would just advocate for, again, for my clients to have the greatest access to care possible, and the most appropriate care in the least restrictive setting. And a care review team may be the place where that's determined in any dispositional alternative in delinquency court. So the care review team is where it all happens for the juvenile whose severe emotional disturbance contributed to the charge. The team has a manual found at the website I've included. And again, you can tell me your experience in working in the care review setting. I would say that the care review team is available for any juvenile that is eligible for a level 3 commitment to YDC or being recommended for PRTF level of care. However, a care review team cannot override an agency's decision regarding service provision or availability. If nothing's available, the care review team can't recommend and ask the court to order a treatment modality that's not available, of course. They are not able to determine eligibility for funding, and they are not able to guarantee that any particular service is going to be approved.
But I'm just going to jump in and give you, I think you have about 12 minutes left.
Okay, no problem. So it's actually anticipated that the attorney for the juvenile is going to be part of the care review team. As you can see from this slide, care review team consists of the juvenile and others, as well as members identified by the wants and needs of the juvenile. And the definition in 7B 1501 is wherever the term juvenile is used with reference to rights and privileges, that term also encompasses the attorney for the juvenile as well. So participation in that care review setting, care review team is important. So if you don't know where your client is receiving treatment, I have listed some websites where you can maybe find out where they are. You can get an idea from the court counselor where they went. And these are the addresses and locations where they might be. On the left are the mental health hospitals, on the right are PRTFs. Now here's what you're up against. You can see that non-hospital based PRTFs and level 4 facilities are concentrated essentially in one area of the state. And I believe we have some participants here from Charlotte, so you know all about this. And they have really the most resources apparently. But you can see that every week there are at least 54 children that are in emergency departments due to a lack of residential treatment options. You know, most of the state has no youth residential treatment facilities. I think that's what someone was referring to that was up in the northeastern corner of the state. We should probably avoid restrictive placements if possible. It does look like even the medical establishment says that PRTFs and more restrictive placements are overused. And I guess these are the people that are evaluating the consumers and beneficiaries that are placed in their facilities, and they're evaluating them. So be aware of that. And don't let someone attempt to use this just because the child has no place else to go. I'm not saying that happens, but if that seems to be the case, that you can see that the medical establishment would support not sending them to a PRTF. There aren't enough resources available as it is. It does look like that there may be help on the way, according to this Division of Mental Health strategic plan. They're going to increase the number of opportunities for juveniles to receive treatment in the community, especially, but also in other settings as well. Necessary treatment is the objective, whether it's in DSS court or delinquency court. And we've already talked about care review teams enough, I think. I just wanted you to see the statutory authority that DSS also has. It almost mirrors in some respects the delinquency court. So a lot of things can happen in DSS court that it can also happen in delinquency court. But certainly in DSS court, they're coming at this problem or this challenge from the standpoint of actually sometimes being the guardian, where they can make certain arrangements and actually make applications on behalf of the child who needs treatment. I know courts are authorized at times to make the application, but personally, in over 15 years of practice, I've never seen an application that's completed by a judge. We do have kids that show up at the facility that come here with DSS, or they come here from a placement where they say, you know, we're bringing this child because their behaviors are such that they need hospitalization, and that's considered a walk-in. And sometimes those children are accepted despite the hospital's diversion policy, but it's not recommended. It's not the safest thing to do, especially if the hospital doesn't have sufficient bed space. I just point that out as something that does occur in the actual practical everyday hospital setting. A DSS case management after emergency department discharges a juvenile with no immediately available alternative. You can see that DSS has statutory authority to get the MCO to do something on an emergent basis and do that a little faster than they might otherwise. But I would say to you that if the delinquency court has convened a care review team, then you're not going to have those problems of emergency discharges and surprise discharges. So that's why I'm trying to advocate for care review teams as much as you can possibly have them. And of course, DSS has their rapid response team, which is adjunct to what I just mentioned in 122C 142. You can read about that. DSS also has the Family Improvement Initiative, where they can get the MCO to act quickly if needs be. And they have a statewide referral system that they can access for therapeutic foster care providers so that they can act quickly. But again, this emergency action may not be necessary if a care review team is reviewed prior to the delinquency court entering an order. And DJJ has a lot of resources that they are receiving grant money for recently. And so always be aware of what DJJ has available. And a lot of their focus is the high fidelity wraparound services. And we're apparently not going to have a lot of time to talk about that, but I'm going to try to get to it quickly. So Trillium's website is explicit about its relationship with the Division of Juvenile Justice, and all the other MCOs have the same relationship. DJJ has juvenile crisis centers, assessment centers, short-term residential centers, multipurpose group homes, transitional residential homes, but I don't think they can take as many children as the mental health system can. Once the juvenile goes to a division of juvenile justice assessment center, there's actually been a study as to the recommendations that that assessment center makes, and you can see that they are mostly mental health treatment type placements, except for there's a juvenile justice type placement there. Foster care is also, that's something that's generally administered by the Department of Social Services. Foster care as well. But the rest of those are part of the continuum of care. And so I'm just going to say the continuum of care is placement of individuals in a level of treatment that matches their health needs. And this is a process that the MCO is going to look for to determine whether a child is to move upwards from a lower level to a higher level of care. And you can see the kind of the progression. All right, so I see that I'm running out of time. I would like to take any questions that you might have, if there's anything, in terms of the slides that I've been over so far. If there's not, then I can maybe just conclude at this point anyway, and have you contact me. My contact information will be available from Yolanda. I'm sorry, there was a lot of information there in the interface between 122C and 7B. And of course, the intersection, the picture of the intersection I showed you previously, I think has been borne out by all the things that I've talked about during this last hour and a half or so. So if there aren't any questions, I guess we can conclude at this point. Is that okay with you, Yolanda?
Yes, and to everybody on, we will send a copy of Ben's presentation with our follow-up email. Nani, I think Eric or Nani put the evaluation in the chat. If you have a couple minutes to fill that out, we will also include that in our email. But thank you so much today for joining us, Ben. We really appreciate you taking the time to teach us about IVCs and commitments in general and how they relate to juvenile delinquency court. I will just pause one quick again to see if there are any questions. I don't think so. So thank you so much. And thank you everybody for taking some time out of your Friday to attend our training. Hope everybody has a good day.
Thank you.